V Lopez. This is the case of Arlene Homol E. Romorosa, petitioner, versus People of the Philippines. GR number 191039, August 22, 2022. This is in the field of criminal law, in which it distinguished the theft from estafa, qualified theft from simple theft. And in the field of remedial law, the allegations in the information. So the facts of the case. Dr. Jelfa Robilos E. Jimenez, Dr. Robilos, hired Arlene Homol y Romorosa as clinic secretary. And at the same time, Dr. Robilos tasked Arlene to collect and remit installment payments from customers who purchased jewelry. Now, on March 2 and 8, 2002, Arlene received a total of 1,000 pesos from Elena Kilangtang for the gold bracelet that she bought. However, Arlene did not give the money to Dr. Robilos. So, hindi binigay ni Arlene kay Dr. Robilos yung bayad ni Elena. On March 14, 2002, Arlene resigned from her work. Nag-resign si Arlene. The following day, Dr. Robilos reminded Elena of her unpaid installments. Elena replied that she already paid to Arlene. Nagbayad na siya. Yung Dr. Robilos aggrieved, filed criminal complaint against Arlene. Finding probable cause, the public prosecutor charged Arlene with qualified theft before the regional trial court. However, the regional trial court and the Court of Appeals found her guilty beyond reasonable doubt of the crime of estafa under subdivision number 1, paragraph B of Article 315 of the revised Penal Code and penalized under the third paragraph of the same article. So, guilty. Guilty si Arlene sa RTC and CA ng estafa. Paragraph 1 subdivision number 1, paragraph B of Article 315 of the revised Penal Code. Now, Arlene's appeal to the Supreme Court. Nag-appeal si Arlene sa Supreme Court, did not dispute the facts, but maintains that her right to be informed of the nature and cause of accusation was violated. Yun ang depensa ni Arlene. Depensa ni Arlene, sabi niya na her right to be informed of the nature and cause of accusation against her was violated. Hindi siya na-inform. Ibig sabihin, hindi siya na-inform sa nature and cause of accusation. That's according to Arlene. The charge was for qualified theft, which translate only to material possession. The information did not allege juridical possession necessary for estafa. So the information did not allege the juridical possession, which is a necessary element for estafa. At any rate, a mere employee does not have juridical possession over the amount supposedly misappropriated and cannot be held liable for estafa. So yun yung depensa ni Arlene, na a mere employee does not have juridical possession over the money supposedly misappropriated. So therefore, hindi siya liable ng estafa. So, the issues of this case. First issue, whether or not Arlene is guilty of estafa. Guilty ba si Arlene sa estafa? And issue number 2 is whether or not Arlene is guilty of qualified theft. So, the ruling of the court are the following. Ano bang sinabi ng Supreme Court? Guilty ba si Arlene sa estafa? Ang answer ng Supreme Court is no. Arlene is not guilty of estafa, but she is guilty of theft. Okay. Bakit? Si Arlene, hindi siya guilty ng estafa, pero guilty siya sa theft. Theft, should not be confused with estafa. Siyempre, although there is the intent to gain, both in theft and in estafa, there is the intent to gain, but theft and estafa are of different. In general, two crimes are distinguished by the manner in which the offender, in each case, acquires possession of the property. Magkaiba. Sa theft, the thief, yung magnanakaw, takes the item without the owner's consent. Kinuha lang ng magnanakaw ang item without the consent or permission of the true owner. However, the estapador in estafa receives the thing and converts it to their own use or benefit. So sa estafa, kinuha lang ng magnanakaw ang item, taking the item without the owner's consent. Walang permiso ng may-ari. Pero sa estafa, the estafador, he or she has the thing. Nandun sa kanya. Binigay sa kanya as a trust. Diba? As a trust. But the estafador converts it to their own use or benefit. However, there may be theft even if the accused was entrusted only with the material or physical or de facto possession of the thing. So, there magkakaroon ng theft kapag binigay, 'di ba? As a general rule, theft can be made by taking the property, the personal property, without the owner's consent. But also, there can be theft if binigay sa kanya ang bagay, the possession, the physical possession. Binigay dun kay Arlene ang pera, ang personal property. And then, kinonvert niya. So, that is also theft. Sige. The misappropriation constitutes theft if the accused was entrusted only with the material or physical possession or de facto possession of the thing. So, that is misappropriation, or the misappropriation constitute it as a theft. Yung na-misappropriate niya yung thing and it is only a theft kapag binigay lang sa kanya yung physical or material possession. Binigay lang sa kanya. Ganun. And then kinonvert niya. Whereas, the conversion constitutes embezzlement kapag sa estafa naman, kapag there is conversion or embezzlement, nagkakaroon ng estafa kapag kinonvert niya if the accused has the juridical possession of the thing. So, the Supreme Court is telling us na kapag si offender, meron lang siyang, yung magnanakaw, meron siyang, binigyan siya ng material or physical possession and then kinonvert niya into his or her own benefit, theft lang yun. Okay? Kapag theft, yung magnanakaw, yung offender, meron lang siyang material or physical possession. Nandun lang sa kanya. Pero, kapag si offender, binigay sa kanya yung juridical possession of the thing, then kinonvert niya into his or her own benefit, then nagkakaroon na ng estafa. Bakit? What's the difference between juridical and physical possession? So, this topic belongs to civil law, which is on property. So, paano yun? Kapag juridical possession, it's given as a trust or in trust or as an administration. Binigay sa'yo as if you own it, but entrusted only for under the direct supervision pa rin ng owner. Pero kapag physical or material possession, binigay lang. Just only pinahawak lang sa'yo, dyan lang muna, ganyan. That's material or physical possession. So, take note that the Supreme Court again is telling that kapag si offender, meron lang siyang material or physical possession over the thing and then kinonvert niya into his or her or na misappropriate niya, then there is theft. Pero, kapag naman sa estafa, the offender has the juridical possession of the thing and then misappropriate, nagkakaroon ng estafa. The next question now is whether the information for qualified theft alleges sufficient facts to sustain a conviction for estafa. So, ano pa pang sinabi ng Supreme Court? Sa case na to, in this case, the Court of Appeals and the Regional Trial Court both held that the prosecution alleged and proved all the elements of estafa under Article 315. Okay, yun yung that is under the ruling of Court of Appeals and Regional Trial Court na prove nila na all the elements are committed, all the elements of estafa are committed under Article 315, Paragraph 1B of the Revised Penal Code. Dun yung sa CA yun, sa Court of Appeals and Regional Trial Court, na prove nila na may estafa talaga. Violation of Article 315 of the Revised Penal Code. However, the information is silent whether Arlene received the money in a fiduciary capacity or an obligation to return the same. The phrase in the information that Arlene ought to remit the money is insufficient, absent the allegation that this duty is rooted in transactions where she acquired juridical possession of the thing. Paano yun? The information is lack. Kulang yung information. Kulang yung information na the information is not clear, does not give an expression or is not clear kung si Arlene ba may fiduciary capacity. Ano ibig sabihin ng fiduciary capacity? Fiduciary capacity means in trust. Binigay sa'yo ang isang bagay in trust. Itago mo yan, pwede mo yan i-manage ng mabuti, palaguin mo yan, you are in trust. Yung mga manager, example of fiduciary capacity, the managers, they are entrusted with prerogatives by the owner. So, the information that Arlene, the phrase in the information that Arlene ought to remit the money is insufficient. Yung nilagay lang kasi sa information is ought to remit. And that is insufficient. Kulang yan. Kulang yan yung ought to remit. Kasi obliged niya, Arlene is obliged to remit the money. Sabi ng Supreme Court is ought to remit is insufficient, kulang yan. Absent the allegation that this duty is rooted in transactions where she acquired juridical possession of the thing. So dapat, para maging liable si Arlene, dapat state ng information na meron siyang juridical possession. Juridical possession, Arlene must have or acquired the thing through juridical possession. Meron siyang juridical possession or in fiduciary capacity. In contrast, the information alleged that Arlene received the money as a mere collector. Nilagay dun sa information na si Arlene is only a mere collector. As such, the money merely passes into Arlene's hands and her custody is only until the money is remitted to Dr. Robilos. Arlene acquires only physical or material possession over the unremitted funds. So, in this case, yung information is not clear. The information is not clear. And the information is only referring that Arlene only acquires a physical and material possession. Physical and material possession lang siya. Bakit? Kasi she is only a mere collector. Mere collector lang kasi si Arlene. She has no fiduciary capacity over the money. Okay? wala siyang fiduciary capacity. Kapag walang fiduciary capacity, then therefore, um, just only just only physical or material possession lang. She is only a mere collector, hindi siya in trust. So therefore, walang juridical possession. So, Arlene acquires only physical or material possession over the unremitted funds. Verily, an employee who receives money or property in behalf of the employer is not vested with juridical possession but only physical or material possession. Yung binigay lang sa kanya yung pera. Binigay sa kanya yung pera with the obligation to remit it to doctor. So, just only receiving the money is only a material possession. So, therefore, she cannot be held liable for estafa, only for theft. Ano pang sinabi ng Supreme Court? An employee cannot be considered as an agent. Okay? Si employee, hindi siya magiging agent if the duty to collect is imposed by reason of his employment. Sabi pa ng Supreme Court, it bears to stress that a sum of money received by an employee on behalf of an employer is considered to be only the material possession of the employee. So, binigay lang sa kanya yung pera. Si Elena, nagbigay ng pera kay Arlene. So, that is only an act of material possession on the part of Arlene. Na-receive niya yung pera with the obligation na i-remit niya dun kay Dr. Robilos. So, that's only a material possession, not a juridical possession. Because Arlene has no fiduciary capacity. Okay? The material possession of an employee is adjunct by reason of his employment to a recognition of the juridical possession of the employer. So long as the juridical possession of the thing appropriated did not pass to the employee perpetrator, the offense committed remains to be theft, qualified or otherwise. Hence, conversion of personal property in the case of an employee of an agent to whom both material and juridical possession have been transferred. Misappropriation of the same property constitutes estafa. Corollarily, Arlene cannot be convicted of a crime not embraced within the information. Nevertheless, the court finds that the allegations sufficiently charge Arlene with qualified theft. So, si Arlene is only convicted for qualified theft lang, not for estafa. Kasi si Arlene has only the material possession over the thing received, not juridical possession. Kapag juridical possession, if Arlene has the juridical possession or in fiduciary capacity or entrusted talaga siya dun sa pera, that's the time magiging estafa. Liable na siya sa estafa. And also, the Supreme Court ruled also na since the information is not clear, then therefore, she cannot be convicted of what has not been alleged. Those alleged in the information, it must be proved. Kapag yung mga circumstances na prove not within the information, then the crime shall only be limited to the information alleged. Ano yun? Sinasabi ng information na may theft. Okay. So therefore, that person must be proved, must be convicted with proof beyond reasonable doubt na convicted talaga siya ng theft. What if pala the court proves na liable siya for estafa, pero yung information niya just only limited to theft? Pwede bang ma-convict ang isang tao ng estafa na in which in the information alleged lang is theft? No, because it's a constitutional violation of the right to know, the right to be informed of the nature and cause of accusation filed against that person. So hindi pwede. Kapag kung ano lang na-allege sa information, yun lang. Kapag na-prove ng court beyond the information, void yun siya. Okay? So, in remedial law, this is in remedial law, what the if the information allege a specific crime, kapag example ang information nag-allege only for theft, nag-allege only ang information ng theft, pero the court proves that it is estafa, the court can only convict the person with what is in the of what was, kung ano lang meron sa information. Kung ano lang sa meron sa information, yun lang. Kung na-prove ng court estafa, hindi yun pwede. That's void. Okay? So we will continue this to the other, we will have this part 2 kasi may second issue pa. May 2 minutes na 20 minutes na tayo. Poryo. Ngayon lang kayo.